In Part 1 of Law and Freedom, we looked at the crisis of authority in the West and how treating absolute freedom and equality as goods in themselves actually creates the opposite, less freedom, as well as an increasingly powerful and distant autocratic state. This time we will look at the main values once understood to be expressed in the concept of legal freedom. Legal scholars in the post-World War II period have generally understood that law functions as a means of directing and imposing restraints upon human activities for the common good of society, or rather the common good of the Westphalian nation-state understood as a society comprised of all individuals or citizens contained within its boundaries. The notion that governments in the West would pass laws intentionally harmful to their own people to serve external esoteric interests or the self-interests only of the governing elites and their friends was still not evident in the early 1960s when Lord Dennis Lloyd wrote his book, The Idea of Law. Another relevant distinction in understanding law and freedom was that between positive and negative freedom. Negative freedom is concerned with organizing a society in such a way that despite the imposition of a multitude of legal restraints to action, the state still left the citizen with a sufficiently large sphere for individual choice and initiative to be able to pursue the good life. In quotes, peace, order, and good government, close quotes, as stated in the Canadian and Australian constitutions, was most likely to be achieved by laying a light hand on the population. A good government permitted law-abiding and productive citizenry as much latitude as possible for work, play, and religious and cultural life, while at the same time providing for just enough of those few and necessary laws, restricting noxious actions to protect the public welfare. The idea of positive freedom was considered at the time more of a, in quotes, spiritual conception, close quotes, implying as it does some kind of maximum opportunity for the self-realization of every individual to achieve his full capacity as a human being, a conception with obvious close ties to radical egalitarianism and materialist universalism. In the early 1960s, it was still thought that the law, by its very nature, must necessarily be concerned with the externals of conduct, rather than the inner state of spiritual development of the citizens, subject to the law. It is therefore hardly surprising, wrote Lloyd, in The Idea of Law in 1964, that so far as legal freedom is concerned, the emphasis is on guaranteeing the maximum degree of negative freedom. It was considered a paradox that the idea of freedom or liberty was embodied in the law at all. Wasn't it where law is absent that freedom would be most likely to thrive? This, of course, assumes the only laws are positive human laws like legislation and regulation and court decisions. The historical processes by which Enlightenment concepts like individualism and individual self-realization, progress, and equality as goods in themselves were turning the tables on the law's relationship to freedom were not necessarily evident until the last 20 years. The attempt to codify and expand basic or fundamental human rights under the post-World War II regime was a more recent sign that things were changing. These codifications were modeled on earlier attempts to take empty formula, as expressed in the U.S. Bill of Rights or the French Revolutionary equivalent, and turn them into legal norms. U.S. Chief Justice Marshall, in the case of Marbury and Madison, which was released in 1803, introduced the doctrine that courts, like the U.S. Supreme Court, had the constitutional power to define the scope of fundamental rights. This was a revolutionary innovation, but it also opened the door to an expanded role for the state through the judiciary and the other branches of government to advance a positive form of freedom. The dominance of negative freedom in Western law is reflected in the legal maxim that everything is legal unless specifically banned, that everything not forbidden is allowed. This was a foundational principle of individual liberty in most Western countries until fairly recently, particularly in common law ones. Roman law also has a similar maxim, nullum crimen sine lege, or no crime without law. The aptly named English judge Sir John Laws famously contrasted the maxim with rules for public authorities. For the individual citizen, everything which is not forbidden is allowed, but for public bodies, and notably government, everything which is not allowed is forbidden. This highlights an asymmetry favorable to the individual. Private individuals enjoyed broad freedom, while government power was restricted to what was expressly granted. How things have changed. We were still a far cry away from activist courts and governments demanding and getting, I would argue, the power to do anything not specifically illegal, and then, sometimes, not even limited by express laws, if politically expedient. Modern human rights ideology sets the stage for the activist state when it introduced positive state obligations. For example, U.S. states must actively protect some rights, for example, the duty to investigate torture, or provide effective remedies under the Convention Against Torture. Under the European Convention on Human Rights, courts have developed positive obligations via the living instrument doctrine, requiring states to act, in another example, to protect vulnerable individuals from private violence. This shift towards positive liberty can fairly be described as a zeitgeist of our times, manifest in widespread state intervention to enable rights fulfillment. Critics warned, without much success, that expanding judicial power into policy areas was dangerous and better left to the legislatures. Philosopher Isaiah Berlin, in his seminal 1958 essay, Two Concepts of Liberty, argued that the concept of positive liberty, freedom to achieve self-mastery or realize one's true potential, is particularly vulnerable to distortion and can justify coercion or government overreach. This is no longer an arguable point in 2025. Consider the ever-expanding scope and remedies under hate crime legislation across the West. This comes very close to the state monitoring the spiritual state of its citizens, who may have or be developing unacceptable views about other citizens or past historical events in need of correction. The other obvious area of positive liberty is the state engaging in efforts to produce actual substantive equality among its citizens by affirmative action and DEI initiatives in every aspect of society, public and private, with particular emphasis on the state indoctrination of children in public schools. The state is also increasingly engaged in campaigns to guarantee physical safety and health, as well as spiritual right-think, by banning and restricting activities and substances and ideas it deems imprudent, such as smoking, or driving without a seatbelt, or reading the wrong books. This only touches the surface of a massive topic of state regulation, with the modern state meddling in ever-increasing aspects of life, from regulations that make it increasingly difficult to be a small-scale farmer, to laws banning ideas that may well be criminal even if expressed around the family dinner table. We also see the state authorizing itself to make choices for the welfare of children without parental consent. Increasingly, individuals may well wonder whether the legal maxim which more accurately describes the current state of law and freedom in our mass societies in the West is, rather, that everything is forbidden unless specifically allowed by law, and that whether one has or has not committed a crime is up to the state. The state will define your right, not before, but after you are arrested and charged, and perhaps not even until you hear the verdict. There are in fact two vastly different conceptions of law and liberty, the classical one and the post-Enlightenment liberal progressive one. By comparing the two, we can see that the erosion of liberty would have been much more difficult before liberalism opened the door to freedom's nemesis. In his paper Law and Liberty, What is the Relationship?, published in French and not yet available in English, I believe, Polish professor and judge Aleksander Stepkowski presents the core thesis that law and liberty are not enemies, nor is law merely the limit of liberty. Instead, law is the necessary condition and the very form in which authentic liberty exists and develops. Without law, liberty degenerates into arbitrariness or license. Without liberty, law becomes oppressive. The classical or pre-modern vision of liberty is reflected in the works of Aristotle and Aquinas. Liberty is the ability to choose and accomplish the good. You have a purpose or telos in living. Law's role is to help man achieve his perfection, as much as such a thing is possible, his purpose. Law educates, directs, and protects true freedom. Even John Locke, the villain in the story of modernism, in many respects, I would argue, also wrote, "Where there is no law, there is no freedom." By contrast, modern liberal progressive conceptions of liberty turn the classical ones on their heads. Since Hobbes, and especially since the Enlightenment, liberty is redefined, as we have seen, as the absence of external constraints, negative liberty. Law is seen only as a limitation of liberty, tolerable only when it maximizes individual autonomy. As a result, law becomes a mere instrument of power or of the majority, and liberty is reduced to license. Stepkowski writes that the paradox of modern liberty is that the more law is seen only as restriction, the more regulations are needed to prevent the chaos produced by unchecked individual wills, which have no telos or purpose. We end up with less real freedom. For example, a proliferation of rights without corresponding duties leads to conflicts that only an ever stronger centralized state can resolve. Stepkowski's argument is rooted in robust classical Thomistic and personalist conceptions. He does not address the problems of multiculturalism, of materialist universalist tendencies in Stoic and modern Christian doctrine, or that the sources of law may include sociological phenomenon. Nor does he address the proper role of the legal system in protecting a people's customs and traditions. Nonetheless, his pure natural law perspective is insightful and relevant even to those who see the three pillars of law, as I do, as comprising natural law, positive law, and custom. He writes that true liberty requires reference to an objective order of goods and values, such as family, truth, justice, life. Positive law that ignores this order becomes arbitrary and tyrannical, even if enacted democratically. Modern constitutional courts, including the European Court of Human Rights, use proportionality to balance rights, but often without an objective anchor. We see this in Supreme Court decisions in the US and Canada as well, which read unashamedly as judges protecting their own personal political preferences and interests. It will be a cold day in hell when a feminist judge rules abortion illegal. This lack of an anchor in objective truth, including, one could argue, without the anchor of a specific people's customs and traditions, leads to judicial activism in which judges impose their own vision of liberty instead of discovering the common good. Law must serve liberty, but liberty must be ordered towards the good of the person and the community. The problem, of course, is that the writer doesn't answer the question as to what happens if the Westphalian state, l'État Westphalien, is now more of a myth than a reality, that Western states are now subject to multiple external treaties and entanglements that our leaders could, but refuse to untie. They are also subject to multiple internal legal regimes within their various new communities, which regimes are only thinly concealed in our time by legal fictions, prosecutorial discretion, and more legislation to correct inequality and injustice. What is clear is that the state and the law must recognize their limits. They exist to protect and promote the conditions in which persons and intermediate bodies, peoples, family, church, association, can flourish in genuine freedom. I would argue that this is only going to happen when the legal system, starting with the law schools, start to produce real jurists again, who understand their role as guardians, tutors, and allies of real liberty and of true law, and stop producing mere activists for their personal causes and protectors of the state and globalist interests. The downward trajectory of freedom under the modern approach is best contrasted by the perceived limits imposed by the state back in 1962, all of which have broken down. At the time he was writing, Lord Lloyd noted that no modern society had considered it desirable, or indeed feasible, to enforce a rigid egalitarianism in all spheres. That is certainly no longer the case in 2025 under the dogmatic DEI regimes we live under. Another limit that has already been brushed aside was freedom of contract. Even in the 1940s, under FDR's New Deal, his Supreme Court recognized that freedom of contract was no longer the pillar of the community it was thought to be. Everyone now recognizes the problems of unequal bargaining power, for example. This was never an issue in pre-modern times when a person, no matter how lowly, had a status within the community that was not dependent on contract. However, under radical individualism, everything, even marriage, is contractual. Where all relationships are contractual, you are liable to be crushed by more powerful players or have your job shipped to the Far East under capitalist doctrine. As a result, standard form contracts, consumer rights legislation, and mass regulation of commerce has left the state involved in almost every contract, no matter how minor the transaction. The right to property has been hit particularly hard. It was assumed that at the very least, property could not be taken by the state without adequate compensation. However, in places like Canada, governments think nothing, and lawyers and courts think even less, of passing legislation gutting property of its value by banning its sale, transmission by will or gift, with the rights passing to the state on your demise. This occurred under the Canadian government's laws with respect to handguns. Courts have also recognized that real property lawfully acquired and transmitted for generations can in fact have a hidden underlying title holder, whose rights have somehow survived the decades. I am referring, of course, to the Cowichan Band land title case in Canada, the full style being Cowichan Tribes versus Canada, the Attorney General. The case addressed an Aboriginal title claim by descendants of the historic Cowichan Nation over land in the city of Richmond, British Columbia. The Supreme Court of British Columbia declared that historical Crown grants of fee simple, that's private title, were defective and invalid as unjustified infringements of Aboriginal title. The decision is groundbreaking because it affirms that Aboriginal title can coexist with and potentially override aspects of fee simple interests, creating uncertainty for property rights. We see here the low value the activist state and its courts place on individual property ownership, which we can expect to be applied in the near future to rural land, small farms, the combustion engine, and other property the state deems inconvenient to its programs. A similar gutting of freedom can be seen in concepts like freedom of religion, association, and freedom of speech. As for freedom of speech, it is now almost reflexive for politicians and their supporters to argue that certain ideas, whether or not incorporated into speech or writing of some form, are in themselves unacceptable. There is little pushback anymore. It wasn't so long ago that it was understood that freedom of speech and the press implied no prior censorship, that works could be freely published subject to any possible legal consequences thereafter, including breaches of the laws of defamation, sedition, or obscenity. But quite apart from the application of the criminal law and hate crime provisions, pre-publication censorship now operates outside of the strict oversight of the state within schools and universities, mainstream media, professional associations, and social media. Long before publication, the utterance of an impermissible view can result and has resulted in bannings, firings, loss of professional memberships, loss of funding, not to mention loss of all access to publication of one's works in peer-reviewed journals, publishing houses, or even access to media through reporters who are no longer willing to listen to, let alone publish, the other side. Lloyd described in his work certain essentials to a democratic form of society as he saw it in the early 1960s. As we listen to his words, we must also begin to look for a new name for our society or a new description of its nature. The current one, free and democratic, comes up lacking in many respects. What can hardly be disputed is that for the purposes of such a scheme of values as is normally associated at the present day with a democratic form of society, there is perpetual need both for an informed and educated state of public opinion and for a high measure of free discussion in all the organs of opinion which society can deploy. A dogmatically established canon of universally valid standards of conduct, however generally approved, which is not open to free discussion and criticism, is unlikely to form an adequate basis for a truly open society.